Thanks for checking out Symphony on YouTube. Please be sure to subscribe and like our videos for updates.
Thank you for remaining with us. Remember, to be part of this program, all you need to do is to, you can follow me on Facebook at EG Osabo. That's where you get me. And you can also go to my messenger, or you go straight to Democracy Today on Facebook. Drop your comment on the messenger so we can talk. We can as well continue our discussion from the program after the program on Democracy Today Messenger. So go to Facebook Messenger, drop your comments. Our second segment is on the PDP primaries bill to hold on Saturday, June 26, 2021. Not just PDP alone. I think APC is also having their primaries in Anambra State. But before we go, we also look at ABUJA, the issue and the different tussle in the political parties. But before we go into discussion on that, let's get the latest developments. The latest on the PDP primaries is that a High Court of the Federal Capital Territory, FCT, Abuja, on Wednesday refused the applications by the PDP to stay in June 9, 2021 judgment, sacking the party's executive, that is the Executive Council in Anambra State. Justice OLUKAYODE ADENIYI, sitting at the MAITAMA division of the court, has specifically dismissed 3 applications filed by the party in respect to the subject matter. And meanwhile, the court further voided the delegates election of the PDP, which held on June 10 and 11 to elect a 3-man ad-hoc ward delegate that would participate in the voting at its primary scheduled for June 26, 2021. In his ruling on the application, Justice ADENIYI held that the 3 applicants, the PDP, NDUBISI, NWOBU, and UCHENNA, OBIORA, failed to make out a case to warrant the grant of their application that sought to stay the judgment pending the determination of the appeal. And Justice ADENIYI, who came down hard on the applicant for earlier denigrating, that's how they put it, for denigrating the court in their reaction to the judgment, held that they did not show that the non-staying of the judgment would either render their appeals nugatory or make it impossible for the party to conduct its primary for the forthcoming governorship election. And the judge voided all the activities engaged in the party since June 9, when the judgment was delivered, including the elections it's conducted on June 10 and 11 to elect a 3-man ad hoc ward delegates that would participate in the voting at the primary of the PDP, scheduled for June 26, 2021. What the justice said, the statement made on June 9 by the state secretary of the party in Anambra, which he disparaged the court, that its judgment was an affront to the court, saying that they do not expect the court they have insulted to grant them an indulgence. Well, that's the line I will drop. I will leave it from there now. You don't expect a court you have insulted to grant you an indulgence. So from there, just start reading it. When a court tells you you have insulted me and I will not grant it to you, I don't know. Lawyers will have to tell us if that is being fair. I don't know about it. So that somebody insulted you today and you say, because of that, I'm not going to grant you grant you whatever you're asking. That's what we'll be looking at. Well, this is not the only thing we look at. So we also look at what is going on in ABUJA. The APC seem to be very quiet in Anambra. Wow. It's the first time that we're having to see the APC, which is not a ruling party in the state, quiet. No issue of court, probably because of their constitution, which put fear is in the minds of most of their members. If you take the party to courts, you stand suspended, not even suspended, you stand expelled. And think that may be why, or maybe at this time, the people, the politicians in APC in Anambra State are disciplined, so they don't want to look at courts, but rather they are looking at what is in it for us come November 6, 2021. Well, joining me in the studio is a lawyer. I have, as usual, Barrister Vincent Otapopo. Thank you very much for coming on the show.
Thank you for having me.
Barrister, let's begin from the PDP. You know, the question I would like to ask is the question I will also ask the PDP executive, if I see any of them today. Yes. With the statement and what the judge said yesterday in the FCT, are you sure they can hold their primaries on Saturday?
The situation is quite a complex one. And it suffices to say that I wouldn't know the rationale behind the decision of the legal team for approaching the same high court that have rendered a judgment and said, this position I have taken. Because that judgment came after the X-ray, the gamut of the issues brought before the court, and the court have handed in a judgment. In my years, so many years of practice, I've never had where a judge, we have to now state his judgment or given any effect to the judgment. Sometimes, psychologically, it will be reasoned that it may be an admission that something may have gone wrong in my judgment or something.
Oh, so it was not possible. That means
no, that is not grantable.
They could have gone to another court.
No, to Court of Appeal.
And okay.
Yes, it is grantable. The same judge, if there is any prima facie case, there are conditions listed under law that a judge can stay execution of his judgment. But remember, that judgment is a declaratory judgment.
Okay.
I wouldn't know what the judge, have to stay. It's a declaratory judgment. Even though there is that thing in the judgment that seems to have, put a command or, compel the party to take a step beyond where they were before coming to the court. That is nullification of the executive and even issues have to do with ward and local government executive that will participate in the election of the conduct of the primary election. Be that as it may, the judge haven't acted yesterday within the bounds and the jurisdictional competence of the court. There is a provision in the Constitution that also gives the appellant right to approach a high court, the Court of Appeal.
Yes.
But judgment of a court which is subsisting, valid, must be obeyed. And in most such cases, it has been said that in a democracy like ours, rule of law must triumph not only in our legal system, but in our body politics. Parties to a litigation must accept the decision of the court in good faith, subject only to appeal processes available in law.
So if it's possible that if they had appealed this,
yes,
if they had appealed it, that means they can hold their primaries. Yes, they can with an appeal.
Yes, I'm coming. No party should employ self-help to disparage or disrespect the order of the court. To the best of my knowledge, PDP did not, to the best of my knowledge, they have not disparaged the order of the court. They came back to the same court. My lord, look at this from this way. Look at the pecuniary or injury that the party will suffer. Look at it this way. And the judge have exercised his discretion. It is also the constitutional bound of the PDP to approach the Court of Appeal. And I'm aware from the legal department of the national headquarters of the party that they have transmitted record to the Court of Appeal. And the appeal is said to be entered when record has been transmitted and appeal number given. And I'm also aware, I think the lawyer told me this afternoon from the legal department, that they have also filed a motion for stay of execution at the Court of Appeal to stay the execution of the judgment of the lower court. These are procedural appellate procedures known to law, which is available to an appellant. But in this case, election matters being sui generis, where issues, activities, conduct of party activities are regulated by the Constitution and the Electoral Act. And the parties cannot go beyond outside the corridor of the schedule of activities issued by INEC. So the party, as the case may be, must proceed to have their primary election. Must proceed to have their primary election.
Despite this from the High Court.
One, if you say I will not have primary election in view of the subsisting court order, assuming they have not gone on appeal, I will not talk like this, I will not argue like this as a lawyer. But having taken a step, and in view of the nature of elections in Nigeria, being sui generis and of time bound by the Constitution and the Electoral Act, they can still conduct their primaries, having entered the appeal. I'm sure the appeal court, because of their procedure now in their Court of Appeal, they will give them date, hear the appeal. If the judgment of the lower court is set aside, that will now regularize what they have done. If judgment is affirmed, to your tent,
Israel.
oh Israel. Everybody will go home. So, but that is what is in the Constitution. But beyond this point, I happens to be in one of these other two cases. What we have in Anambra State PDP, there are a litany of judgments today. And which one do we obey? The latest judgment is what we have today. It may interest you to note that the claimant in this particular judgment
of the FCT
High Court, which is Samuel Anyakora and others, had approached Federal High Court in Anyakora, I think 877 or thereabout, 446, which I participated. I appeared for the entire World Executive of the Anambra State People Democratic Party, elected at the World Congress of 25th of November 2017. In that case, they said they were duly elected, and they put up their results and their reports and what have you. But the party briefed us, PDP, who filed our processes. We raised a preliminary objection and said that the suit is incompetent at the Federal High Court. We raised up to 8 grounds of appeal, but my lord of the Federal High Court singled out one of the grounds I raised, which is that the subject matter before the court borders on pre-election matter under section 285 subsection 9 of the Constitution and must be supposed to be filed within 14 days. That argument might sound new and archaic to some people, but the Supreme Court emphasized and brought this to bear in the case of APC versus Ibrahim Omar, where they said that PDP, as the case may be, as case in point, the conduct of PDP World Congress and local government Congress being a process for the election of world delegates, statutory at the world level, yes, and the 3-man ad hoc delegate that will participate at the primary election, be it gubernatorial primary election or national assembly or state assembly, constitutes a pre-election because it's a process leading to an election. It's a commencement process to an election. Supreme Court reasoned. And by the provision of section 235 of the Constitution, the finality of actions of the Supreme Court has been founded and consecrated, which is also replicated under section 287, subsection 1 of the Constitution, that the judgment of the Supreme Court binds all parties and all inferior courts throughout the Federal Republic of Nigeria. That is the case. So we won at the FCT, Federal High Court. But my lord, in his wisdom at the Federal High Court, because of the application from the lawyer to the plaintiff, consolidated my PO and the entire suit together, and it was hard together. So he delivered ruling on my PO and said he cannot proceed to the main suit because it's a waste of time to proceed into the gamut of the this thing. So these parties went to Court of Appeal, which was contested up to the Court of Appeal. And Court of Appeal, in the 2 grounds of appeal they raised, they said, one, that my lord of the Federal High Court was wrong. Having considered my PO and the entire gamut of the substantive action filed by the plaintiff, my lord supposed to have, having ruled on the PO, also make findings on the substantive matter so as to afford the Court of Appeal opportunity to review the exercise. 1. 2, that they refused to agree that the matter is a pre-election matter, which I have argued and the court accepted at the lower court. The judgment of the Court of Appeal came 15th of February this year. What did they do? They said, having looked at it, yes, plaintiff, we agree with you. The matter is not pre-election matter. We try to distinguish from this case, between this case and what the Supreme Court, which I relied on, did in APC and Ibrahim Omar. That is another case, another discussion. So they agree with them that it's not a pre-election matter. They also agree with them that the judge, having taken the entire proceedings together, PO and the substantive action, having ruled on PO, supposed to also pronounce on the substantive action so as to afford them opportunity to review the exercise. And this case file is hereby remitted back to CJ of the Federal High Court for the assignment before another court. This fellow abandoned the exercise and proceeded to file this action that gave rise to this judgment now. Yes.
So that one, they abandoned that.
They abandoned one. And it suffices to note that the subject matter in the previous case, we are raising the question of they were elected as a valid elected state Congress, executive, and World Executive, and the 3-man ad hoc committee. That issue Court of Appeal have acted. And you know, by section 287, subsection 2, so Court of Appeal is the second in command in hierarchy of courts. And each judgment binds every person and authority throughout the Federal Republic of Nigeria, including the inferior court, FCT High Court, Federal High Court, High Court of Anambra State. Now, from what it looks, the question and determination as to who were validly elected ward and local government executive committee members of the primary election of the Congress conducted on the 25th of November 2017 and 1st of December 2017 is a pending action at the Court of Appeal. It has not been determined.
So why would the FCT
now,
come up with it?
The lawyers that filed the action at the FCT High Court, I think I thank them for their maneuvering, the way, you know, construction of question for determination. The lawyer tried. Instead of raising the issue as to whether they were validly elected or not, he now raised the issue because the PDP printed their brochure here in Abuja, and national officers were appointed from Abuja here to go and conduct zonal congress at Enugu sometime in March 2000 this year. That because their name was their name were omitted, those plaintiffs, their name were omitted, that it clothed them with cause of action. They approached the High Court here.
So what's the implication of this whole issue now? The
implication of it is that, as it stands, legally speaking, unbiased, the question and issues relating to the validly elected ward and local government executive of PDP in the last 2017 election of November has not been determined, because by order of the Court of Appeal, which is superior to this letter judgment of the High Court, and this other lot, there is other judgment even from FCT High Court in Buhari that have also held and legitimized the executive that this order sought to remove. And that is first in time.
So that means all this one put together, it is the Supreme Court that will determine what will happen.
It is the Supreme Court, but it suffices to say that the highest judgment in this whole thing now is the Court of Appeal judgment that have remitted the question and issues as to who were the validly elected executive in Anambra State.
If they have this, why are they not saying the primaries may not hold when there is a Court of Appeal judgment pending?
They will tell you that the questions as to the judgment of the FCT High Court is far-reaching. It went beyond issues.
Okay, of the executive.
Yes.
And they talked on the Congress is held in March.
Congress is in March, state executive, even up to ward.
They tied it.
Yeah, they tied it. So, and you know, every judgment of a court is a substituting order and must be obeyed. The sanctity of court judicial system must be respected. So, it behoves on PDP, in view of the surrounding circumstances. Look at these are the judgments here. This is the one from FCT High Court on leadership of the party at the state level, legitimizing what the executive they have in Anambra now, which this court now has nullified. This one legitimizes it. This is the one from Federal High Court I cited before, which we won, and they went on appeal. This is the judgment of the Court of Appeal of March this year, February this year, remitting the matter back to Federal High Court for a trial before another judge. And this is the latest judgment of the FCT High Court. Okay? So in all this, haven't entered an appeal, and in view of the superior judgment earlier delivered by the Court of Appeal,
the party can go ahead.
The party can proceed.
For their primaries.
For their primaries.
Okay.
That is my opinion. But assuming they have not entered the appeal, transmitted the Court of Appeal today, I will tell them they should go and they pray to God for vengeance. But and they should respect the judgment of the latest judgment of the court of the FCT High Court.
By Service said, this issue we still need to look at it because it's looking like
dicey.
Yes, it's reminding me of what happened in the 2019 election.
Yes.
The Zamfara APC as well as Rivers APC.
Yes.
So it's a pre-election matter, and at the end of the day, they didn't have candidates.
Yes.
So, like you said, the PDP needs to be on their toes.
Yes.
Of this. But let's quickly, before you go, because our time is far-fetched, let's look at the issue of APGA. Yesterday, some people came out to say they suspended the candidates that has been elected in a primaries. And if you go to INEC portal, what you see is that Victor Oyi remains the national chairman of the party. So they were holding a primaries, and another group came out to say, this one, we are suspending you, who says you are a candidate, because of anti-party activities. And also the INEC issue too. INEC has said they have written what they have written, and if the parties that are aggrieved feels that what the steps INEC has taken, they are not comfortable with it, they should go to court. Does that not mean that something is in front of ABUJA if they are not careful?
Yes, I'll answer this question with reference to the provision of paragraph 15, part 1, third schedule to the Constitution, where the powers of INEC has been laconically provided. Where you marry it with, and also section 15, 85 and 86, giving of the Electoral Act on the powers of the Commission to monitor electoral activities and regulate political issues like that. Now, the philosophical thinking behind that paragraph 15 of the part 1 third schedule and the methodical intendment of section 85 and 86 of the Electoral Act, to me, it's not that INEC will now descend into the arena to begin to determine for a political party who to sponsor or who not to sponsor. No. It appears to me, legally speaking and constitutionally speaking, that the purpose of this law is to bring in a regime of fair play, democratic elected process, and justice in the conduct of affairs operation of political parties. INEC, in their letter of 18th of June 2021, addressed to the national chairman of APPLICANTS, whether it's the former or current, I don't want to delve into that conflict, but addressed to them, document speaks for itself and cannot lie, unless contradicted by another document, and you cannot even contradict it by oral statement and evidence. So that document reads, Oga, we are not aware of the list of delegates you say submitted to us, or the Congress you said you conducted to elect delegates. By the provision of so and so law, we are supposed to monitor and participate in the conduct. Their lawyer too wrote for certified true copy of the list submitted by APUJA, and as well as list of the report of INEC with respect to the Congress. INEC also replied the same lawyer and said, you are seeking information under Freedom of Information Act. We cannot oblige you because we don't have such a record. Now, under section 131 of the Evidence Act, it says, he who alleged the existence of any fact must prove that such fact exists by cogent, compelling, and credible evidence. INEC has given out documents. Look at our letter to them. APUJA, bring your own document to show that you have submitted the LEMS to INEC. Simple. In all this, we have not cited the document.
But the argument now that ABUJA is raising is that section 85 that INEC quoted has nothing to do with the delegate election or whatever. That is it's solely a party issue.
No.
When it comes to delegates.
I disagree with them.
Let me read it. The argument is saying is that 85 says every registered political parties shall have the commission shall give the commission at all level at least 21 days notice of any convention, congress, conferences, or meeting convened for the purpose of electing members of its executive committee or other governing bodies, or nominating candidates for any of the elections. So what they are saying is that this is for primaries, not for congresses, not for delegate congress.
Wait.
He said it's for primaries.
Every political party shall give the commission at least 21 days notice for convention. Congress, what is Congress? Congress is an election. It's an election where those delegates supposed to be elected. It is said Congress.
But this can be argued in courts.
When the letters of the law are unambiguous, plain and simple, you cannot give it any other grammatical meaning. They are very simple. You say Congress, give them 21 days notice. Okay. Remember, in the case of PDP and Sylvia, which was also implicated in the case of Shinkafi and Yare, Supreme Court said that INEC has constitutional power, statutory power, to issue guideline schedule of activities guiding political party. And in the case of Dangana and Usman, Supreme Court expanded that powers to say that even in PDP and Silva, that INEC guideline and schedule of activities is like a rock of Gibraltar or a Mount Zion, cannot be shaken.
Barrister.
A political party wanting to field a candidate for election must conduct primaries within activities within the law and guideline of INEC.